Hi everyone, my name is Meghan Cookson, and this is my presentation on the competence to waive the right to counsel and to represent oneself. So in chapter 6, we learned about adjudicative competence or the competence to proceed. And in this chapter, we're teaching each other about the different types of decisional competence. So decisional competence is the competence to make a particular decision during a criminal justice situation. But before we delve into that, I just wanted to briefly touch on parents' pie tree. In the past, the state has had the power to make decisions for those who cannot care for themselves via parents' pie tree, and this translates to state as parent. Melton et al. States that, quote, since the mid-19th century, much of Western society has subscribed to the principle that human dignity demands respect for individual autonomy unless compelling reasons to infringe upon that autonomy exist, end quote. So essentially, the state cannot use parents' pie tray power unless an individual lacks the ability to make a specific decision or perform a specific act with regards to courtroom activity. And as a result, decisional competence is a very neglected forensic issue. Melton et al. Explains that, quote, the decision that is probably most likely to have an adverse effect on a defendant's ability to achieve a fair trial is the waiver of right to trial counsel, end quote. This decision is almost never in the defendant's best interest because it leaves them without legally trained counsel. So you're probably wondering, why would someone waive their right to counsel and represent themselves? And this can be for a variety of reasons. Maybe the punishment isn't severe enough to justify the cost of hiring a lawyer. The defendant might plan to plead guilty anyways, so hiring a lawyer wouldn't do much good. They might believe that lawyers are incompetent based on past experiences, so they just want to try to do it themselves. They might be trying to make a political statement by not giving into the quote unquote oppressive system that they think lawyers are a part of. Or they may be trying to gain privileges while awaiting trial, like access to the law library. And just a quick aside, Ted Bundy had access to the law library when he was acting as his own attorney, and he actually ended up escaping from the law library through an open window during a court recess. And lastly, they're not bound by the same ethical codes as lawyers, so the defendant may try to delay proceedings by filing unnecessary motions. So some important Supreme Court rulings that we're going to be discussing throughout this presentation are Ferretta versus California in 1975, McCaskill versus Wiggins in 1984, Godinez versus Moran in 1993, and Indiana versus Edwards in 2008. So in 1975, Ferretta versus California, the Supreme Court of the United States upheld that the Sixth Amendment guarantees a criminal defendant right to self-representation. The court acknowledged that although this decision may be detrimental to a defendant and increase their chance of criminal punishment, the freedom to choose is protected under the Constitution. So this ruling did not define the competence to waive counsel and represent oneself. However, the court did make it a point that a defendant is not incompetent to waive counsel just because they don't understand legal jargon and rules. Earlier court decisions had suggested a higher level of competence is required to waive the right to counsel than to stand trial or plead guilty, but this level of competence has never been defined. So in 1993, Godinez versus Moran affirmed that a person who is competent to stand trial is competent to waive their right to legal counsel. And as stated in the court decision, quote, the competence that is required of a defendant seeking to waive his right to counsel is the competence to waive the right, not the competence to represent himself, end quote. So defendants have the right to self-representation, even if acting as their own defense is to their own detriment. In order to waive the right to counsel and represent oneself, the defendant has to be apprised of the disadvantages that come along with self-representation. And this is to ensure that they understand the potential consequences of their actions. Essentially, the defendant must understand the ramifications of waiving their right to counsel in the eyes of the court. And also upheld in Godinez versus Moran were that the court does not have to ask the defendants their reasons for such a waiver or deny it if the reasons are irrational. So if someone is found competent to waive their right to trial counsel and does so, but then proceeds to trial, the court can appoint standby counsel on their behalf. So in 1984, in McCaskill versus Wiggins, the court affirmed that, quote, A defendant who successfully waives the right to counsel can nonetheless be forced to proceed with such a counsel, as long as he or she retains accrual control over the case presented to the jury, and the jury understands that the defendant is representing him or herself, end quote. So if these conditions are met, the standby counsel can actually aid the defendant by offering advice and information pertaining to court proceedings. So in 2008, 14 years after Godinez versus Moran, it was basically overturned by Edwards versus Indiana. In Edwards versus Indiana, the court stated that defendants who are competent to stand trial and waive the right to an attorney are required to have an attorney if they, quote, still suffer from severe mental illness to the point where they are not competent to conduct trial proceedings by themselves, end quote. And this was really done to maintain dignity in the courtroom and allow fairness to defendants. However, the court once again did not define what makes someone who is competent to stand trial but incompetent to represent themselves. They only indicated that this includes the inability to perform basic trial tasks. So routine competence to proceed evaluations do not include competence to represent oneself. This is because it is assumed that someone with adjudicative competence will not attempt to get rid of their attorney. So defendants usually attempt to waive their right to counsel after adjudicative competence has been established, which leads to additional competence evaluations. And these involve a clinician ensuring that the defendant understands the tasks they will be required to perform as their own attorney and their reason for wanting to defend themselves. The latter part of this is used to see if some type of mental disorder may be at play. Some common alerts to clinicians that the defendant's attitudes towards the legal process are impacted by mental illness are as follows. First, we have defeatist attitudes, which would be something like, no lawyer can help me because I am guilty. Then we have paranoid ideations, something like the lawyer and courts are out to get me. Next, we have fantastic objectives, something like I can defend myself because the person I murdered isn't actually dead. And lastly, we have irrational beliefs, like supernatural powers will allow me to be found innocent. So if these attitudes are present, the court has historically declared such defendants incompetent to defend themselves. However, if a defendant's reasoning for wanting to defend themselves is that they think they can do it better than a lawyer, or they just simply disagree with their lawyer, their competence to defend themselves is likely to be upheld in court. In conclusion, Melton et al. States that, quote, if the defendant is able to communicate with the defense counsel and testify relevantly, and if the defendant can give rational reasons or waiving counsel, the defendant should be permitted to proceed pro se. Indiana versus Edwards affirms that additional competency evaluations are needed for defendants who wish to represent themselves at trial. This is to ensure that they are able to carry out trial tasks as necessary. Ferretta versus California upheld that one's constitutional right to self-representation cannot be violated simply because it will be damaging to the defendant's sentencing. It is important for clinicians evaluating this type of competence to pay special attention to the cognitive functioning of the defendant, since this has not been addressed by the courts in a legal ruling. So for my media source, I have included a link to an article entitled 10 Cold Killers Who Made the Mistakes of Representing Themselves. And in the top right corner, you'll see a picture of Ted Bundy. And in the bottom corner, you'll see a picture of Charlie Manson. These are two pretty notorious cases. So for my discussion question, I'm wondering, is it ethical for courts to allow pro se defendants to cross-examine their victims? This is something that Ted Bundy did in his trial that has definitely been highly debated. Thank you all for watching, and please let me know if you have any questions.